Hello, Jim Miskell from the Estate Planning Law Group of Georgia. Today, I wanted to talk to you about the big secret. One big secret about probate court that a lot of folks don't realize. We talk a lot and have been talking a lot recently about whether or not will plans or trust plans are right for families. Just to recap a little bit, the difference between a will plan and a trust plan when you die is the route that your family takes to get to the distribution and administration of the estate. With a trust, you've set it all up so that the authority is self-contained within the trust. With a will, in order to get the authority to make the moves required in the will, the family takes the will to probate court. Probate being the place where we prove that a will is valid and should be followed. 2 years later, both work equally well. Everything's distributed the way it should be. It's just a difference in that administration. Here's the thing that most people don't think about with probate. Why? Why do I call it a big secret? Because everybody hears probate and they think this is when you die. They may think gun licenses and marriage licenses and those things too. Those are other things that probate courts do. But when they think about planning estate and what happens with folks' estates, they think probate court happens when you die. There's another time. This is the secret I wanted to tell you, is that your family can end up in probate court if you become incapacitated and you haven't made a plan for that. If you become incapacitated and you haven't made a plan for it, your family ends up in front of a judge asking them to say, in my case, Jim's lost it. He's round the bend. Give us the authority to act on his behalf because he's making crazy decisions with his property. It's totally unlike him, and he's putting at risk everything he's set aside, everything he's worked so hard to accumulate and set aside to take care of himself in old age. That's when folks end up in probate court. Those proceedings are for establishment of a conservatorship or a guardianship. In some states, they're under the same umbrella of guardianship. In Georgia, probate court divides those actions into two separate actions. One is a guardianship, and that's over a person. Those are the decisions about daily life and the personal welfare of that person. Conservatorships are about the financial estate. So those could be different people. Just as you set up your own planning, you may have different people on your healthcare directive than you have on your power of attorney. Those might be different folks in those roles. Very frequently, though, it's a close family member handling both those roles. So when does this happen? When do these petitions for guardianship or conservatorship happen? Well, like I already previewed for you, it's when somebody goes around the bend and they start making decisions that are uncharacteristic for them and harmful either to themselves or to their financial well-being. And the family files a petition to say, Judge, we need to get a conservatorship or a guardianship. And the first question the judge wants to know is, does this person actually need one? That's where the fun really starts because you've taken me to court. If you're saying that I'm no longer able to handle my affairs, I take offense to that. I've got a problem with that. I say your grandfather or your father may not remember, he may have Alzheimer's and may not remember what he had for lunch an hour ago. But till the day he dies, he's going to remember that you're the one. You're the one that took me in front of that judge and tried to get the judge to say I was crazy. So what happens? The first the petition is filed, just like with a probate for a will. Everything in probate court starts with a petition. You file the petition and say, here's our evidence that this person cannot handle their affairs. And you either get a couple of family members in on that or a couple of people, or you may have a healthcare professional, social worker or a physician to file an affidavit. But then the fun really starts because you may have competing doctors on both sides. it's a lot of fun for the family to go spend time there, especially when they're worried about the financial well-being of the family. So all this, and why I'm talking about this today, started with a phone call. And this was a phone call to Mark Brown. Mark's dad, retired Army Colonel Brown, lives here in the area, and Mark and his brother live not too far, but not locally. Got a call. Actually, Mark and his brother Ken both got phone calls from the neighbor across the street and said, essentially, have you talked to your dad lately? So I'm like, no, what do you mean? I think you need to call your dad, the neighbor said. They called Dad and found out that Dad was feeling great. Everything was going very well. And if you'd had lunch with Colonel Brown, you'd say, that is a great guy. What great stories he tells, sharp as a tack. Turns out he was so sharp that he realized that he was winner of the Publishers Clearinghouse. Somebody had gotten his cell phone number and called him and said that he had won Publishers Clearinghouse. The only thing they needed was processing fees to handle that. And it was very important that the processing fees be paid only in cash, U.S. cash. Colonel Brown then, per the instructions of Publishers Clearinghouse on the phone, took $15,000 cash. He went up to the credit union, got $15,000 cash and put it in an envelope and put it in the U.S. mail. What became clear as Mark and Ken began speaking with their dad was that he'd lost the ability to make good decisions with money and tell the difference between a get-rich-quick that was clearly not honest and good investments. They were faced with a situation where Dad was liable to squander everything he'd set aside for his own care. Mark and Ken weren't really worried about inheritance. They were worried about Dad being able to pay his own way, which had always been really important to Dad. So here's the thing. Colonel Brown had done some planning ahead of time. He wasn't worried, his family wasn't worried about going to probate after he died because they'd done a living trust. The other thing that he'd built into his plan was disability planning. Colonel Brown thought it was important that if he became unable to manage his affairs, he didn't want a judge to decide. He wanted people that he knew and trusted to decide. So he set up as part of his plan, if I lose touch, I've got this provision that can take things out of my hands and put it right into my successor agents. Let my sons handle everything for me. And that's exactly what happened. Family didn't spend a long time in court. As a result of that, unfortunately, lawyers didn't get hired. I'm being silly. They didn't have to pay a lawyer, so that was good. And a fight didn't break out. Why? Because Colonel Brown had done that planning ahead of time. So that's the second place. That's the big secret about probate court, is the family may end up fighting in probate court if you become disabled. There's a way around that. I just wanted to talk to you today about that because folks so many times rush right to what happens to your stuff when you die when they think about estate planning. And it's about so much more than that. It's about making sure that what you've worked so hard to save and put aside is there for the purposes that you saved it. And it's protected, even from your own bad judgment. As things may unfold for you, you may lose the ability, like Colonel Brown did, to make good decisions about what should happen next. It's something that's important. Everybody should think about what their family will face as things unfold. Give our office a call. We can have a conversation, talk about what's important to you and your family. Make sure that you've got disability planning in place so that you're not punting the decision to the local judge, somebody that doesn't know you. That's pretty much what I wanted to talk about today, was that big secret time that folks don't think about when you can end up in probate. Not just when you die, but when you become disabled. I'm Jim Miskell with the Estate Planning Law Group of Georgia. Call our office, set up a consultation. I'd be happy to meet you and talk about your family and what's important to you. Have a great day.